You're listening to the Divorce and Your Money Show, the #1 show on iTunes discussing the complex business of divorce. I'm your host, Sean Lehman, MBA and Certified Divorce Financial Analyst. And in this episode, we're having our first repeat guest. His name is Larry Sarezky. He is one of the most experienced family law attorneys in the United States and also the author of what I consider to be one of the best divorce books out there. He wrote the book called Divorce Simply Stated: How to Achieve More, Worry Less, and Save Money in Your Divorce. Now, if you are getting started in the divorce process and you're doing your research, you have to buy this book. There is almost no other better divorce book out there that's straight from a family law attorney. And as I said, he's the first guest who's been on the show twice, and that's for good reason. His book is excellent. And what I want you to do is I want you to go to Amazon, get his book, get the Kindle version. It's super cheap. It's less than $10, and it is packed full of information that you will want. And once you're done with the book, I want you to write a review. Help him out and help increase the profile of his book because, as I said, there's no one who's read this book who's disliked it. And if you take an extra minute after you've read it and get the information, leave a review of Divorce Simply Stated for Larry. And so in this episode, we cover one of the first chapters in his book. It's actually chapter 2. And we're going to go through some myths that people have. Most people have a lot of misinformation when it comes to the divorce process. That's because there's just a lot of bad information floating out there, a lot of just bad advice, people who want to give their opinion and don't really know what they're talking about. And it can lead you to have some ideas in your mind that aren't quite right when it comes to the divorce process. And so Larry and I are going to go through, and he's going to walk through some of the major divorce myths for us and bust them. Tell us why they're wrong, and this is a great episode that you don't want to miss. So without further ado, here's my interview with Larry. Today on the show, I have with me Larry Sarezky. Larry is a matrimonial lawyer, mediator, writer, and also the author of Divorce Simply Stated: How to Achieve More, Worry Less, and Save Money in Your Divorce. Larry, welcome to the show.
Thanks, Sean. I'm glad to be here.
And as the listeners might know, this is actually the second time we've had Larry on the show. You are the first repeat guest we've ever had. And if people have heard the first episode, it's episode 54, where we discuss how to choose a divorce attorney. And we go through that chapter in that section in your book, Divorce Simply Stated. And today I want to get into some myths that people have about the divorce process. You have a great chapter, chapter 2 of the book, called Divorce Fact Checking. You know what section I'm talking about?
I do.
Excellent.
I wrote it.
Good. Well, we're going to go through some of them because a lot of the listeners have some misconceptions about divorce. And there's also a lot of just bad information floating around there. So let's jump right in. The first myth is that legal separation is just when you live apart from your spouse pursuant to a written agreement. What do you make of that?
Well, it's not true. I can say it pretty simply. What a legal separation is a judgment or decree that you get at the end of a lawsuit that is very similar to a divorce. So it's called a legal separation action or case. And the only difference between going through that process is that once you get your judgment of legal separation, you can't remarry because you're not divorced. But in every other respect, it's the same. So what do I mean by that? You can resolve all the issues having to do with property settlement, dividing up your property, support, that's child support or alimony, and all the children's issues, a parenting plan, how you're going to spend your time with your kids and split that up. All of those issues can be resolved in a legal separation action. But as I say, at the end of it, you can't remarry. Now, you might wonder, well, why do it at all then? And the answer is that some folks, for various reasons, sometimes religious reasons, sometimes because they just can't quite pull the trigger on a divorce, feel more comfortable starting a legal separation action. The good news is that it can be changed very easily in midstream to a divorce action if either one of the spouses wants to do that. So it's not as though you have to start all over again. And the other thing I'll say about it is that, you might say, well, all right, so maybe I'm wrong about that. What's the harm? Well, there is some harm in believing in these myths, all of them, including this one. For example, the written agreement that you have may or may not be enforceable. If there's no divorce case pending when you make an agreement that you think is a legal separation but isn't, what you don't have is the contempt power of a court to enforce that agreement. That's something that you get in a divorce action, or if you've actually started a legal separation case, you have a judge who you can get to quickly and say, listen, we have this agreement and my spouse is in violation of it. But if you've just signed an agreement and you haven't started a case in court, you don't have that. And, that's a big drawback.
Yeah, I think you brought up a lot of interesting points on that one. And I want to ask some follow-ups specifically on this one. The first is that it sounds like, if I understand you correctly, that when many people, I should say, speak colloquially, or just, in casual conversation, that I'm separated and, I live in a different place from my spouse, that doesn't have any legal ramifications the same way that legal separation does, or how do you think about that?
There's nothing wrong in saying that we're separated. It has practical significance. You're living apart, but it doesn't have the legal significance that people think it has, and that's the problem. And they call it a legal separation. Well, we've separated and we've agreed on a few things, but it's more a description of the fact that you're simply living apart.
That's interesting. And then the other thing you also said is legal separation is almost identical or is virtually identical to the divorce process, with the exception of, at the end of it, you're legally separated and not divorced. So it sounds like if you're thinking about separation, you should basically think about it that you're going to have to deal with all of the exact same concerns that you deal with if you were going to get through a divorce. It's just the end result is a little bit different from a legal perspective.
That's right. And there's one other thing I should point out. I said that you can change a legal separation case into a divorce case while it's pending. You can also do it afterwards. 2-3 years later, you can turn that legal separation in every state that I know of into a divorce decree. However, the judge is going to have to make a determination that the agreement that you reached was not only fair at the time you reached it, but is also fair at the time that you come before the judge 2 or 3 years later and say, okay, we have this legal separation decree, we want to make it a divorce. And, things may have changed during those 2 or 3 years. And, an undesirable consequence is that agreement that you worked hard on might be found by a judge in light of new circumstances, one of the spouses hit the lottery, no longer to be fair.
Yeah, I think that's great information. That's one of the questions that people ask me all the time, is about the separation versus divorce process. But I think you just illustrated a lot of really important points that people don't necessarily consider. So let's move on to the next myth. And that is, no-fault divorce means that family law judges cannot take into consideration the reason a marriage broke down. Why don't you tell us more about that one?
Oh, yeah, that's a good one. That is also not true. I mean, some of these myths have, some kernels of truth. This one doesn't. What no-fault divorce is, and this started in California a while back, was the first state to adopt no-fault divorce, is the fact that neither spouse has to be at fault for the breakdown of the marriage. There doesn't have to be any what we call marital misconduct. If two people who are married want to get a divorce, they can get a divorce. And with New York being the last holdout, they finally adopted a no-fault divorce statute 2-3 years ago. all of the states now permit no-fault divorce. Now, in some states, regardless of the fact that they are no-fault states, evidence of marital misconduct or evidence of the reason that the marriage broke down is admissible. And those are probably a minority of the states, but it's a completely separate rule. The state either allows or doesn't allow evidence of that kind of marital misconduct. So even though you're in a no-fault state, and everybody is at this point, in some of them, that evidence is still admissible.
Got it. And let's move on to the next one, which is property gets split 50-50. And we're going to talk about, and you should probably define both of these as well, but property gets split 50-50 in community property states and in equitable distribution states.
Yeah, that's a common misconception as well. I mean, I've had many clients come in and say, well, this will be easy. I'll tell you what we own, and, we're just going to split everything 50-50, and, here's $500. That ought to cover it. Unfortunately, that's not true. That's why I started doing mediation, because the divorces are so expensive. But let's start with community property states. There are 11 and a half of them, actually, and I'll explain what I mean by that. But in a community property state, there's a concept of, strangely enough, community property. And that is defined as usually as any earnings produced by the labor of the spouses and property purchased with those earnings between the date of the marriage and the end date of the marriage. Inheritances, most gifts, and certain trust assets, as well as property acquired before the marriage, all of that is excluded. So whoever owns that, whoever inherited the money, whoever owned the property before the marriage, that's theirs. And it's not there to be split up. Once you define, what the community property is, then it usually is divided 50-50, but there are exceptions to that as well, and it depends on the states. And I can get into more detail if you like, but let me talk for a second about equitable distribution states. So we have 11 and a half community property states. And the half, by the way, state is Alaska, which is an equitable distribution state that allows couples to elect community property treatment if they want to, which is kind of a strange rule. I think they may come from looking too long into the sun trying to see Russia from your front porch or something like that. But it's a strange, it's not a bad rule, actually. It gives people that alternative. So what's equitable distribution? What are these other 39 states? Equitable distribution simply means that the judge has the authority to divide property in a fair, that's equitable, fair way, not necessarily equal. So now many judges start out with a marriage that's at least 5 years, a very short-term marriage. Often the property goes with the person who either came into the marriage with it or generated it in an equitable distribution state. But in marriages of some length, judges often start out at 50%, and then the spouses or the lawyers can try to convince them why a 50-50 split is not fair. But again, there are things that are off the table that are not included. In most equitable distribution states, like community property states, inheritances and property acquired before the marriage is often not included in what the court has the authority to divide up. Does that answer it?
That does. No, I think that's very helpful. And if you ever watch movies or television or just talk to people, I think the perception is just you can walk in and chop things in half. And even there's some funny advertisements to that effect. But that is obviously not the case. I want to shift gears a little bit and talk about children. One thing that many people might not know is you are one of the foremost experts in custody and parenting and children issues in the divorce process. And so I want to talk about a few custody and child-related matters and myths that people have. The first being that joint custody means that parents divide their time evenly with the children?
Yeah, that's a no also. That's not true. And the first thing to do is to draw the distinction between what's called legal custody and physical custody. So legal custody is decision making, essentially, how the parents are going to divide up the decision making, or how they're going to make those decisions together, which is better if they can do it. And then physical custody, as the name suggests, means where the kids are going to be, how the parents are going to divide up the time with the children, where they're going to live, and all of those kinds of details. We used to talk in terms of visitation and custody. Now, more often we use the term parenting plan, which is doesn't trigger the kind of emotions that visitation. That's just a bad word. Let's say it's dad who moves out of the house and the kids are living with mom. I mean, visitation is not something that dads want to hear. They want to hear about sharing time with their kids and participating in all the things that make child rearing a good thing. So that's an important distinction. So we're talking here about physical custody, dividing evenly your time with the children. And that's just not what joint custody is. It means that you have a parenting plan by which you're splitting up your time with the kids in a manner that is fair, but most importantly, and this is the standard that every court applies, in a manner that's in the best interests of the children. So you hear sometimes parents say, well, I have my rights as a parent. And, a lot of judges will look at that parent and say, sir or madam, what I'm interested in is the children's right.
Right.
And, that's paramount. And that is, and what should be, what drives these decisions. And the last thing I'll say is, please, to parents, if you can possibly work these details out, do it. You don't want to have to submit these kinds of issues to a court, because the kids get caught up in a process that you don't want to see them go through. And you're basically turning over to somebody who barely knows you the decisions that you should be making as parents.
I want to jump on that last point for just a second. It sounds like, and more than sounds like, I would say you strongly recommend that, if you're getting divorced, you can come up with a workable parenting plan on your own without the attorneys, and kind of have your attorneys maybe figure out the final details to make sure it's legal. But you can decide that on your own if you're willing to do it.
Yes, you can certainly come up with the broad strokes, the general concept. And, like any agreement, it's in my view, always good to have a divorce professional, and that includes lawyers and divorce coaches and financial analysts who can tighten up the language, who can point out to you things that you might not have thought about. But yeah, listen, if you married your spouse, you must have had some things in common. And some of the things you had in common probably had to do with child rearing. You have some shared values. And I often tell people the first step to get to a parenting plan is to sit down together, hopefully, and make a list of all the things you agree upon with respect to the kids. That could involve religious training, it could involve education and sports, and also some things that are specific to divorce, like we're not going to convey messages to each other through the kids. We're going to shield the kids from any conflict that we have, and then agreements about how you're going to talk to the kids about the divorce, what you're going to tell them, and, all the rest. So you can build on that kind of list of shared goals. That's a great place to start, and then get to the parenting plan based on those shared principles.
I think that's great. And you mentioned a subtle tip in there, as you said, start with everything that you agree upon. And that's a good way to start making progress, at least working out issues that you do agree upon. And then later you can deal with the things that you might disagree upon. But starting on a positive foot is certainly a much better way to get closer to some sort of agreement in that respect.
Yeah, absolutely. And one reason is that it creates momentum. You say, oh well, we agreed on this, and let's try this one. Let's try this issue. There really is a momentum, and I see that particularly in mediation, where I always start with children's issues, because parents who come into mediation are usually on the same page generally about children's issues. And so, once we start resolving them, you see that momentum building, and parents, without lawyers will experience the same thing, I think.
I think that's great. So let's move on to another myth, also in the children-related area. This one is that I don't need a lawyer to figure out my child support because anyone can look up the child support guidelines chart.
Every state has what are called child support guidelines. They're based on the incomes of the parents and the number of children as a kind of the two basic ingredients. And I say in the book that I say it a little more crudely than you did. I say we don't need a lawyer because any dope can look up the amount of support that the child guidelines calls for. And what I say in the book is, yeah, but you better hope that dope is a lawyer. And here's why. As I said, the two ingredients are the number of children and income. The trick here is to make sure you're using the right income. And different states have different rules about how income is defined. It's not necessarily the income on the pay stub, because pay stubs can be very misleading as to what your net, that is, after-tax income really is, for a variety of reasons. Some people have seasonal employment, so, their pay stubs at any point in the year may show either that they're making more than they wind up making on average or less. The number of exemptions, you fill out that W-4 form if you're employed, and you specify a number of exemptions. That can affect how much money you have. And then, of course, if you're a homeowner, at the end of the year, you do your taxes, and you've got a sizable deduction for mortgage interest and property taxes, and you might get a tax refund. So, again, that's not reflected in a pay stub. Then you have people who are self-employed, and, that takes some looking into. And lawyers and divorce financial analysts and divorce planners are really good, hopefully. I don't know so much about some of the lawyers, but the financial analysts I've worked with have been really good at ferreting out, what, let's say, who has her own business. What is she really earning? What's she really getting out of this business? That takes a little bit of looking into.
Right. I think that makes a lot of sense. And one last one for the audience. And this one is that child support and spousal support obligations can be avoided by filing for bankruptcy.
Yeah, that's a no. Also, it just ain't true.
I think you're going to upset a few people with that one.
Well, maybe so, but hopefully it'll reassure some people who are on the other side of the equation. And child support and alimony are not dischargeable in bankruptcy. That means they don't disappear, even if the person who's paying, that is what we call the obligor, because we're lawyers and we have to use words like that, goes into bankruptcy. And again, this is where having a divorce professional can help. You can structure your agreement so that things that you might not think of as child support, for example, will still be considered child support. Things like attorney's fees, money you paid your lawyer to get child support, and you're getting reimbursed from your spouse. That can be considered child support that, if your spouse goes into bankruptcy, you will still get money that you put aside, whether it's for orthodontia or that kind of thing. If you think your spouse may be going into bankruptcy, make sure that that's not considered property settlement, that money that you set aside. Make sure, because property settlement awards are different. But if you want to protect it as child support, say in the agreement, this is in the nature of child support.
Got it. And so, on that vein, what happens if someone, were to lose their job and then cause another host of financial obligations or complications, and they're responsible for paying support? How does someone protect themselves in that situation?
Yeah, that's a really good question. It doesn't happen automatically, and I've seen people learn that tough lesson too late. If you lose your job and you are under an order, whether it's a temporary order while your divorce is pending or a permanent order at the end of your divorce, you want to file a motion with the court right away. It's a motion for modification. That's what it's called in most states. You simply say in the motion that you've lost your job and you're asking for relief from child support order. In most states, you don't have to put a whole lot of detail in there. And then, you will have a hearing and you can just lay out the facts. And the judges have pretty broad discretion to suspend the order, to modify it, that is, to reduce it. And, they're not going to terminate child support, but they will give you some relief if you've been unemployed, especially if it's gone on for a while. I mean, if you're out of work for 2 or 3 weeks, you're not likely to get much help. But, if this drags on, it's only fair. And judges understand that you need some help there.
Got it. And also, if you're on the other side of that same equation and your ex-spouse loses their job and they're paying you support, is there any other way to protect yourself, or you should just kind of expect that things might change?
There are some arguments to be made if you're on the other side, which is that, listen, my spouse has a fair amount in savings, and depending on the law of the state, that certainly may be a reason for a judge to say, well, listen, let's see how this goes. But for the next couple of months, you certainly have substantial savings, enough to be able to support yourself and your children. And so I'm going to keep this order in effect and then come back in 2 months. You might get an order like that. But that's certainly a persuasive argument to be made by the recipient of child support. Let's say it's mom, because her finances may be every bit as tight as dad's.
Got it. I think that is very helpful for people to think about. So for people who want to learn more about you and your work, what's the best way for them to contact you?
They can go to the website, which is www.divorcesimplystated.com. And there's a contact page there where they can reach me, or they can simply email me at info@divorcesimplystated.com.
Excellent. Well, Larry, as always, it's a great pleasure having you on the show, and you always have such helpful information for the listeners.
Well, thank you, Sean. It's certainly my pleasure.
We've reached the end of the episode, but before you go, I want to make sure you check out some really important information at divorceandyourmoney.com. When you get there, sign up for the email list so I can keep you updated with exclusive information and content that you won't find anywhere else. Also, you'll find the one-on-one coaching services where I get to work with you, the show listeners all over the United States. I'm easy to work with, I'm responsive, friendly, and I'll listen to you. We'll get to get deep into the details of not only what's going on in your divorce case, but your life as well. I end up knowing a lot more than your divorce attorney ever will because I don't charge by the hour, it's fixed prices, and you can reach me anytime. We get to work together, understand your situation in depth, your financial picture, and help you get to a settlement that makes sense for you not only today, but for the rest of your life. And I also get to keep you out of trouble and keep you from making poor financial decisions. Attorneys are great at the law, but they're not financial experts, I should say. And a lot of times I see them end up making settlement mistakes that will cost you for the rest of your life. They could be tax inefficient, forcing you to take the wrong asset that you shouldn't be keeping, or trying to get you access to money that you won't really have access to until you retire. And sometimes you need to know those things in advance and keep you out of trouble while the divorce process is going on, because it's hard to change afterwards. And also I get to keep a long-term relationship with a lot of you, because even after the divorce settlement is over, you've signed the agreement, it doesn't mean that the process is over. You need to move on with the rest of your life. I have clients that I get to work with for years at a time. I've worked with for years after the divorce is over. They're still clients. I know their families. We go on vacations together. We know their kids, and their kids know me, and we get to have a very nice long-term working relationship. And it all starts with a simple introductory call. We'll talk for 20 to 30 minutes. You just go to the coaching tab on divorceandyourmoney.com, fill out a short form, just tell me what's going on. We'll set up some time to speak. And once we do that, we can start and proceed from there to see if coaching is right for you. I love working with you. It's exactly why I do what I do. And the sooner you book an intro session, the better. You know, it says that you know that you need the help, and you know, it makes easy working with you because we can get into the details of your case and help you craft the settlement that you deserve. Now, book those now, because I want to make sure that I maintain a high level of service with me and my team, and sometimes there's a wait list. And if you don't get on top of that now, I don't want to keep you waiting for weeks at a time, where sometimes things in divorce can move by the hour. Now, also while you're on the website, check out our courses. If you like the show, there are some great courses you can get there. They're longer, they're more in-depth, they include visuals, handouts, and even more details as you go through the divorce process. They cost less than the one-on-one coaching sessions, but you'll get a lot of great information from them. They're well worth it. They're better than any book that you'll find on the divorce process out there. And it's me teaching it. It's me talking to you just like I am right now. And it's more in-depth than what you'll get on the show, but it is a great place for you to learn. Some of the courses that are available right now is there's Divorce 101 course. It's called Steps to Take Before Divorce, everything you need to know before hiring an attorney, and also Divorce 102. It's how to get a divorce without losing everything, 12 ways to avoid common divorce mistakes. They're great courses. A lot of people I know love them. And if you like the show, it's a great place to get more information that I don't talk about here. Plus, as I said, lots of additional resources and custom handouts. And if you don't like the course for any reason, I have a 100% money-back guarantee, and also there's bonuses. So for the people who take the course and you say, you know what, I've spent the time going through the course, getting organized, learning all this really important information with me, and I want a one-on-one session. I want to work together. Well, I give you a discount, a big discount, for going through the course and learning that information that is well worth the time that you spend and the money. And the reason is for the people who've gone through the course, and they all love it. The people who've gone through the course are so well informed by the time they start working with me that it's worth the discount that I give, because it's just so easy to work with you. And last but not least, leave a review of the show on iTunes if you enjoyed it, and share this information with a friend, and be sure to subscribe so you're automatically updated with new episodes as they come out. I'm your host, Sean Lehman, MBA and Certified Divorce Financial Analyst. Thank you for listening.